Yes, welcome everybody. Thanks for joining the Contentious Clinic today. This is the next in our series of our death to distribution series. Just to recap, this is the second session in our death to distribution series. It's a follow-on piece from the first session, which was discussing the immediate issues after death. And this session is going to look at the early days of the dispute. Joining us today, we've got Eleanor Stenson, who presented on the last one, who is one of our partners here. And we've got Kate Lister, who has just become an associate here at IDR, probably been a month or so now. I'm probably a bit behind, but yeah. And she's going to lead the session today. So I'm going to leave you with them, and we'll come back to you at the end of the session. Thank you.
Thanks, Lindsay.
Thanks, Lindsay. So last time, Eleanor and I were here a few weeks ago, and we discussed the various issues that might crop up immediately after someone has passed away. This included searching for wills, disputes over funerals, burials. If you didn't catch this clinic, then it is available on our IDRN. If you want to have a look back through that. This time we are going to have a look at potential issues that might occur after death but before the grant is taken out. This includes potential claims, obtaining the grant, information requests, caveats, letters of claims, and we'll go through all of this with you in this clinic. So one of the first issues that we often see relates to who is entitled to take out the grant. The legal position is that where there is a will with a named executor, those named executors are entitled to take out the grant of probate. You might find that an executor is either unwilling or unable to take on the role, in which case they may renounce. Some common reasons for executors renouncing include the estate being insolvent, or they might not have the time to take on the administration, or the deceased might not have informed them that they were going to be an appointed executor and they just simply don't want to take on the work involved. Or it might be that an executor has concerns relating to the validity of the will, and they might be seeking to challenge the validity of the will. In which case they wouldn't ordinarily take on a grant and seek to deal with the administration. Where an executor has renounced, if there are any remaining executors appointed in the will, then they can continue with the administration and they'll make the application for the grant. Where there are no remaining executors, there's a strict order of priority for taking on a grant of letters of administration with the will annexed. This includes beneficiaries of the estate, and you have to work through the list until you find a suitable person to take out the grant. It's worth pointing out that an executor who has started the administration of the estate will be considered to have intermeddled in the estate, which means that they can't just renounce in the same simple way. It's therefore usually advised that if an executor intends to renounce their position, that they do so quickly and before getting involved in the administration of the estate, just to avoid any later issues in trying to renounce at a later point. Where there is no will, the rules of intestacy will kick in. There's an order of priority again to both inherit and to be eligible to take out the grant of letters of administration under the rules of intestacy. This normally starts with any surviving spouse, children or their surviving descendants, then their parents, siblings, and so on. Where there's more than one person who's entitled to take out the grant under the rules of intestacy, once the grant is obtained, it will become on a first come, first served basis. Where there's more than one person entitled to take out the grant, the court will consider who is the most eligible to administer the estate. For example, a single parent who's passed away with two children, one is an adult, one is a minor. Both children are entitled to take out the grant, but if a dispute comes up between the two of them who's most entitled, the court is more likely to favour the adult child as opposed to an alternative adult on behalf of the minor child. So it's just something to consider where you've got more than one person who seem to be equally eligible. And it's probably at this point is a good point as any to remind everyone to carry out a will search of the National Will Register, even when you have located a will, just to be sure that there are no later valid wills in existence, because this will obviously have an effect on who's entitled to take out the grant, if the executors have changed throughout wills, or if we believe that there is no will in the first instance. So please do carry out your searches, make sure you make all of your relevant inquiries. We did cover this in more detail in our last clinic, so do feel free to go back and have a look. But if not, we can always provide more information. Eleanor is now going to talk you through some of the potential claims against the state at the early stage.
Thanks, Kate. Yes, those of you who did catch the last session will remember that I signed off by saying, you know, we have these immediate issues that crop up, you know, emotions are running high, and often there can be some steps that are taken by beneficiaries or others straight away. But otherwise, we often see that after the dust has settled, you know, following the funeral, and you know, as a bit of time has passed, that this is the crucial point at which people start to build their cases. Perhaps they've now got a copy of the will, or perhaps they are concerned that they haven't got a copy of the will, or do not know what is happening with the estate and want to find out. There are all sorts of factual reasons which can lead into this, but ultimately the first claim, which I think is probably the most obvious in respect of time limits, is any claim under the Inheritance Act 1975. The reason for making you aware of this and raising this at this point is that obviously there is a strict time limit that applies to making any claims, which is 6 months from the date of the grant. Obviously, our talk today is about pre-grant claims and issues being raised, but if there is a suspicion of a claim, or there is a you know, a concern that the provision that an eligible beneficiary has been given by a testator or by the deceased is not reasonable, then even before the grant has been obtained and that time limit starts to tick, they should be starting to build their case, you know, as early as possible with this, because there is often a lot of factual and evidential matters to take into account when bringing these claims. So rather than allowing that time to start ticking following the grant, these early steps are important. I've just listed out here the eligible claimants. Our previous webinar series covered these in more detail, but just by way of reminder, these types of claims are open to close relatives and those who were financially maintained by the deceased, and who may have a claim to say that any provision they were made in a will or the provision under the intestacy rules is not sufficient and not reasonable for them. The time limit to make a claim is 6 months post grant. Quite often, even if letters of claim and issues are being discussed between potential claimants and the deceased's estate, it may be necessary to issue the claim, but then agree that that sort of dialogue and that discussion over those issues will continue, whilst you know, trying to avoid the costs of having to take it to a trial. If you find yourself after the 6 month time limit, then the court's permission will need to be obtained to bring any claim. And the court has given varying responses to such applications. So it's really important to prepare any claim as early as possible, and in any event to stick with that time limit. Looking now at other types of claims, the next one to mention is validity challenges. So there can be a real issue if the last will that is being discussed and it is looking to be the one that a grant is being obtained on, if that is somehow under suspicion, if there is a concern that it isn't the last will, then of course whoever is appointed in that will might not be the right person in the eyes of the law. And so it's so important that if there are questions over this last will, that these sort of reasonable searches are undertaken. But that also, if there is a resulting challenge to that will, there may be a completely different methodology for distributing the estate. And so an early claim, even though you're not bound by the same strict time limits as an Inheritance Act claim, an early steps being taken to build your claim here are really important, because obviously if there is a dissipation of the estate under the terms of, I've put here, the wrong will, then that can create even further practical issues in recovering those monies or assets to the estate. If you are intending to bring a claim to challenge the validity of a will, you've got to have standing. Now, the Latin maxim here is locus standi, but that means you've got to have the right to bring this claim. You can't just have a third party who is concerned, a neighbour or a friend who is worried that people might be trying to go against the deceased's wishes. You've got to have an interest in either an earlier will or an intestacy position if you are looking to bring this claim. And this flows on to how you go about building your case, because again, when you're trying to access information to support any challenge that you might have, you also have to show, particularly for medical records, you have to show that you have an interest in the estate if the disputed will is overturned in some way. So where we're looking at these early steps being taken to build a case, we're looking at asking the right questions of the people who were there. So that's the witnesses to the will. It's looking retrospectively at who was looking after the deceased before they died. Is there any issues with their capacity? Was anything raised that could give evidence to suggest that the testator wasn't able to sign their will at that point? That all these pieces of the puzzle start to be built up and the case created layer by layer at this stage. So this is very much fact-finding and making sure that all avenues of inquiry are being exhausted at this stage. I'll hand back to Kate to talk through caveats.
Okay, so carrying on from Eleanor here and considering the potential claims against an estate, it's a good time to start having a think about caveats. A caveat can be lodged with the probate registry by an interested party to stop a grant from being issued. You might lodge a caveat against an estate if you're concerned that the will is not the last valid will of the deceased, and you perhaps need some time to make the relevant searches, investigations, or you do not believe that the will is the valid will, and you want to challenge the validity of the will itself. Your caveat can be used in cases of intestacy as well, perhaps maybe where you've got more than one person entitled to obtain the grant, but there's a dispute over who is the best person to do so. So they have got a good range of uses, and ultimately by lodging the caveats, you're putting a hold on the administration of the estate whilst the dispute is being considered by the parties. The easiest way to lodge a caveat is online. You can do this through the gov.uk website, or you can download the relevant form and send this on to the probate registry by email or post. There's usually a fee of, I think it's £3. Once your caveat is lodged, it will remain in place for 6 months. This usually gives you a good amount of time to start all your initial investigations and, like Eleanor said, start building your case. When after that point it will automatically expire, and then it can be renewed in the weeks before it's due to expire if the case is still ongoing, you've still got searches to make, and so on. Eleanor has made some notes as well on what happens once your caveat's in place, dealing with warnings, but I'll let Eleanor take over now.
Yeah, sure. So basically the caveat is there to stop the process of the administration of the estate. And in those cases that I talked about earlier, where you are concerned that there is the wrong will being put to probate, or that even if it's the right will but the wrong person administering it, then there are plenty of reasons why it's necessary to put a block on the administration of the estate to stop it being distributed and dissipated in the ways that we've already touched on. So if the caveat hasn't been removed voluntarily by the caveator, or it's expired after the 6 months and hasn't been renewed, you can file a warning to say to them, this needs to be removed because either we don't believe that you have sufficient standing to put in a caveat, or actually we are willing to agree as the estate that we won't distribute, pending resolution of this claim. The warning essentially is a document from the probate registry which says if you have got no good reason for having this caveat in place, then it will be removed. But if you are able to justify your position, then you've got to put that in writing, and you've got to send it into the probate registry as an appearance, which is a formal response to this warning. If that is put in, then the caveat is made permanent, which means that nobody can then unilaterally remove it, and it doesn't expire. This can then only be removed by a court order, and this can create problems in those early stages where there is a permanent caveat, and sometimes the distraction of the process of dealing with that and the court application that comes with it, rather than focusing on narrowing the issues. However, from the alternative view, you have the importance of making sure that estates aren't administered whilst ever there is an ongoing dispute. So it's an important tool in the armoury here. Looking now at information gathering again, I've already talked about approaching witnesses to wills and also looking at medical records, but this is a tool that the Larkin-Nugis request is a tool for potential claimants to ask questions of the drafting solicitor. So again, this is enabling everybody to start to build this puzzle, put in the pieces of the puzzle of what happened at the time the will was signed. We're looking at the medical evidence for potential capacity issues, but also we're looking at the solicitor's file and asking them what their understanding of the testator's capacity was at this point. The reason that this case is one which comes up time and time again is because it solidified the Law Society guidance on what a solicitor should do if faced with questions about a disputed will that they've drafted. In essence, the court's position is that a solicitor should respond to such requests. They can't claim privilege over it, that the testator has died, and they can't claim that information is confidential, because to disclose the information might resolve the dispute sooner. And that is something the courts want to see. They want to see early collaboration and discussion and narrowing issues between the relevant people. They don't want to see knee-jerk, hair trigger applications for court-ordered relief. It is possible to make a charge for responding to these requests, but it's got to be reasonable. And with all of this, if there is any questions that are being raised, the more transparent and open the responses are, the better, because ultimately the solicitor can be called to give evidence at trial. So those early disclosures and being transparent with the file of papers and your recollection of things will only serve to make your evidence more compelling and make the process easier for you.
So that leads us on quite nicely, thinking about information gathering. And once you've got all of the relevant information and evidence, you are then in a position to put your claim forward. This is usually to the beneficiaries of an estate. The next step is to prepare your letter of claim. The relevant practice direction set out by the court confirms that the parties will be expected to exchange correspondence and information that is relevant to their claim, with a view to understanding each other's position and to attempt to settle the dispute without issuing formal proceedings in the court, if it can be avoided and if it's not necessary. So the first step is for the claimant to provide concise details of their claim and evidence in support of the same. Most practitioners in this area of law will follow the ACTAP's code and guidelines, which expand on the practice directions set out by the court. There is some really helpful guidance in the ACTAP's code, which will help any practitioner ensure that they are providing appropriate information and supporting evidence relating to their claimant's claim. Most practitioners would consider it best practice to produce an ACTAP's compliant letter of claim. So really, in essence, it is the full details of your client's claim, the claimant, and all of the relevant information and evidence that you've worked so hard to gather and to put forward is all concisely together in one letter, one document that will be put to the other parties. Once the letter of claim and all the supporting evidence has been put forward, the defendant will then have an opportunity to respond to that claim, which I will let Eleanor discuss in further detail.
Thank you. Yes, in essence, the sending of the letter of claim, it puts the estate on notice. It also makes it clear to the estate that they should not distribute or take any real steps to advance the administration of the estate until that claim is resolved, because it could have an impact on the methodology of the distribution. It could even mean that the people in charge of the estate who read the letter of claim are not ultimately the ones who deal with it. So it is very important for it to be sent to the estate, which means the executors, or it means the personal representatives. With that, there is a very good chance that they will be told in the letter of claim, if it's drafted fully, that they ought not to advance any sort of argument or take any or favour anybody within the dispute. They have got to be neutral, and this means that they are highly restricted on how they can respond to the claim. They can't fight it on behalf of the beneficiaries. That is for them to do. So they are taking the front line. And usually what happens is the executors receive the claim, and then they send the letter on to the beneficiaries to fight it out amongst themselves. They are the ones who are interested in the outcome here. So it is for them to defend their inheritance and maximise their inheritance. And so because of that, they don't have the same restrictions on neutrality. And so they can argue their case, and they can defend their position accordingly. Quite often, letters of claim are tens of pages long, and because of that, and because of the issues that are being raised right at the beginning, it does often mean that people need more time to engage. Kate's talked about the best practice and the pre-action protocol, and of course everybody tries to stick to that, but it may be the case that further time's needed, and the courts are very keen to see this early collaboration and early agreement to additional time if it's needed and it's reasonable. This doesn't stop urgent applications, but it does give people the time and space to respond to numerous allegations or requests for information in the right way, and to allow that sort of early disclosure and transparency where possible to be undertaken. That is it from me on that side. We're looking to the next session. Kate, I don't know if you want to just give a brief overview on what that's going to look like for everybody.
Yeah, so as Eleanor says, this brings us to the end of this clinic. But in the next clinic over the next few weeks, the focus is going to be on the issues that arise after a grant is obtained. This is including pursuing these potential claims that you've put forward, and possibly even mediating at an early stage. Whilst me and Eleanor are finished, please do stay around, because Lindsay's got some really good information to pass out to everyone.
I might just share my my slides on this, Kate. So I'll just swap over.
Yep.
Share mine. Okay. Okay.
Thanks, Eleanor. Thank you.
Problem.
Yeah, so I think we're just wanted to take a moment really to share a bit of information on the IDRN. I think there's going to be a link going into the chat now for you, for anybody who hasn't registered. I think most of you may be aware of the IDRN, but if you're not, it is our dedicated online referral and support space. We've just actually relaunched the IDRN, so we've just had version 3 come out. So the IDRN's been going for 2 years now. We've got over 1,000 members on there. Version 3 is really important because it really leans into that education and knowledge piece for us, which is something that the IDRN really needed. It needed that a space where it had lots of up-to-date sector news in there. And this key feature is called IDR Intel. It's headed up by partner Stephen Lawson, who is also the head of the chair of the Law Society Wills and Equity Committee. So there's lots of good information on there. So the piece that came out in November, we had a piece on regulatory changes. So that was a full article on changes to the non-contentious probate rules. There was also a case summary in there. So that highlighted the recent case of Waldrop and Searson. And what Stephen does is he provides a 10-minute clip on this, so a bit of a roundup, and it just provides commentary, his opinion and comments, and it gives you the chance to listen in, so you don't have to read everything in depth, because we know how it's quite time precious. And we also have a comments box on there, so you can ask any questions and give feedback. The IDRN also is a place where you can fast track any referrals across to us. So if you just skip to the nenext slide for me, Eleanor, that would be great. So yeah, it's a space where you can, as I say, you can fast track any referrals. So if you've got a client there that you've is in the early stages and you're navigating that contentious state with them, you can simply complete their details in our fast track referral space, and that'll drop straight into our triage. And we can then give them a ring back within 24 hours and keep you updated on that referral process. There's a page within the IDRN that explains our full referral process, and part of that is fee shares. We provide 10% fee shares on any clients sent over to us, and we keep you up to date on progress of those clients. So in terms of where the inquiry's up to, how it's going, and in terms of whether they've been converted to matter, and that comes in the form of a monthly report that's sent to you and the team at the beginning of each month. As part of the IDRN, you can also book onto our specialised training sessions, and they take the form of something called, if Eleanor, you skip to the next slide for me, brilliant, thank you. They take the form of something called Bring Out Your Dead. Now, a bit of a crazy name. We did wonder whether we should call it Bring Out Your Dead, but it started to make sense, and people found it quite funny, and it's inspired by the famous Monty Python sketch of the same name. So if anybody remembers Monty Python, you'll remember that. These sessions give our referrers and potential referrers the opportunity to bring out their problem dead files that they may have lingering around on their desk and they don't know what to do with, and they just need a bit of reassurance. Usually in these meetings, 70% of those files, we are able to just give guidance and reassurance to your non-contentious teams. And obviously in a few of the cases, our involvement will be needed, and we can help with any of those sort of dev files immediately. I noticed, Eleanor, you've unmuted yourself. Is there anything you wanted to add on those sessions?
Yeah, I was just going to chip in just to say how effective they can be, and it's something which you know, I know so many of my kind of non-contentious practitioner former colleagues and friends in the space who will be a bit concerned about giving the sort of contentious guys a ring to discuss it, when actually they're trying to pick through it themselves. And you know, if you think about it in a way of, you know, having us come in and sort of sit there with you and go through the file and talk things through, rather than you know, it being something you need to have prepared and to have considered yourself and think about the potential routes through a dispute. We can do that for you completely, no, you know, no pressure, no issues at all from our side of things. It just is a helpful conversation, essentially.
Mm. Yeah, and they've proven quite popular, and you can basically do them on Teams, you can do them in person. It's completely up to you. We're completely flexible around you and your team. So if you're interested in one of these types of sessions, or you just want to have a bit more of a chat about how they work, you can either contact me, my email's on the screen, or you can go onto the IDRN and complete the booking form, and there's a section there where you can add in a preferred date to talk and all sorts on there. So yeah, so please, I just urge you to go and have a look at the IDRN. Again, it's free, completely free, loads of CPD resources, all of our contentious clinics. Contentious clinics been running for it's probably 2 years now, so there's lots and lots of CPD on there to take advantage of. Just to finish up, as Kate says, the next session on the Deaf to Distribution series, that is coming out in January. In December, we decided to do a bit of a light-hearted Kahoot quiz for everybody. So if that's of interest, please do contact us and join that session. And if you subscribe to the IDRN, you'll get our IDRN newsletter anyway at the beginning of December, updating you on that. But thank you. Thanks, everybody, for joining. Thanks, Eleanor. Thanks, Kate, for the session. Really interesting.
Thank you.